Welcome to the Dickinson College Expert Show, where we connect you with insight from Dickinson College's faculty and leaders. I'm Craig Lane. Thanks so much for joining us. It is a privilege to have in the studio with us Dickinson President John Jones. President Jones, thanks so much for being here.
Craig, it's great to be here.
All right, and the reason that we want to tap you as a Dickinson College expert is because in addition to being the college president, President Jones hung up his robes as a federal judge to lead his alma mater. So we're here to get some legal insight from you, and we really appreciate you taking the time.
Well, I swapped, the black judicial robe for the red academic robe. So.
Absolutely. It suits you well, I think.
Well.
We are here today to make sense of the multiple trials involving former President Trump. Obviously, very serious subject matter and a lot of ground to cover in a relatively short amount of time. But want to tap your insight as a former federal judge here and sort of get an idea. We've got 4 major legal cases going on. Is there one of them that you see rising above the rest to maybe be the most solid case from a judicial perspective, or maybe the case that puts the former president in the most legal jeopardy?
I think, and that's a wonderful question, I think the one that is most problematic for the former president is the Mar-a-Lago case, quite clearly. I don't know how he gets out of the box that the prosecutors have him in that case. It looks to me that if the government can prove at trial the facts that they've asserted, which is that, for example, his attorney told him he had to deliver these records back to the archives, or he would risk being raided. And in the intervening 2 weeks, it appears that he's got some former employees who are going to testify that he ordered them to move the materials to keep them away from anybody that would be coming pursuant to a warrant. That's obstruction of justice, and I don't know how he gets out of that, quite frankly, let alone the fact that he's retaining for months and months documents that they're calling for. So I would think, from sort of straightforward prosecution, that's the closest thing to a slam dunk that the feds have.
That's interesting to hear you say that, obviously, because this case, much has been made of where this case is taking place, which is in Florida, where, of course, Mar-a-Lago is. But much has been made of the judge in this case, too, Aileen Cannon, who was a Trump appointee. You have written that you think she will play this one like an umpire, that you don't expect any favor towards the former president despite being one of his appointees.
No judge, wants their judicial epitaph to be that they screwed up a case. And she had a bad go-round with the case that she was involved in previously, and took a pretty hard whack from the circuit court when it was appealed and sent back to her. I think that she's clearly has the capabilities to be the presiding judge. She was thoroughly vetted. Yes, she doesn't have a wealth of experience. She's only been on the bench a couple of years, but I believe in the federal judiciary. No judge is perfect, but I'm hopeful that, at the end of the day, she's able to manage this case. But I think it has a decent chance to get to trial, perhaps before the other cases in which the former president's involved.
That's interesting you say that, because, of course, these cases will be going on at a time when Donald Trump is running for president once again. So this is an interesting situation. He'll be off the campaign trail. He'll be in court a lot. But you think the Mar-a-Lago documents case is the one that might actually make it to trial first?
Either that or the Washington, D.C. prosecution in front of Judge Chutkan. That case as well, involves some discovery aspect, meaning that things that get exchanged from the prosecution to the defense that I think that they can finish up. That has a shot to go. The case that I don't think will go is the Georgia state case, the Fani Willis prosecution. Honestly, I think there's too many people in that array of defendants. Most prosecutors try to limit, as Jack Smith did, by the way, in Washington, where he only indicted Trump and the rest were unindicted co-conspirators. That is really representative of a prosecutor saying, look, I don't want to complicate this case. You know, my target is the former president, and I don't want to encumber the case with other defendants. Fani Willis, for whatever her reasons, you know, indicted 19 people. And frankly, from a judicial standpoint, if I were the presiding judge, that's a nightmare, because now you see you've got a couple of defendants asking for a speedy trial, which means you may have to try part of the case or part of the array of defendants, and then you're going to have to try it again with other defendants and try it again. You cannot, although when she had a press conference, I saw her say that she wanted to try everybody all together. There's no humanly way, Craig, that you can try 19 people at the same time. It's a logistical mess. Think about the inside of a courtroom where you have to have, places for 19 defendants and their lawyers. Now, to be sure, in that case, you'll see some people plead out. That's the natural way that it happens. There won't be 19 at the end of the case, but I think there's going to be a fair number of defendants. Plus, we don't know yet, but there may be a removal of some cases to the federal court based on various theories. And you know, she still has to represent basically the prosecuting agency in those cases. So she's bitten off a lot in that case. We'll see where it ends up.
So that's why it would take a lot of time then to get to trial.
Yeah.
And you're saying multiple trials possible then if
Yes.
you have to break out all those defendants.
Yes,
Wow.
and I think, you know, that is what's known as a RICO case, and a RICO is essentially a corrupt enterprise. It's, you know, in its origin, RICO was designed to roll up the syndicate, the mafia. Now it's being used for other purposes, but those are complicated cases because you have a lot of moving parts, and you have to show the criminal enterprise and the different things that create the criminal enterprise. So that, I don't have any particular hope that that case will get tried at any time before the election in November of 2024.
One more thing I want to ask you about the Georgia case, and that's the Georgia case will have cameras in the courtroom, which is something we're not used to, especially with federal trials. Again, this is a state trial, but different rules. What we're used to in Pennsylvania is no cameras in the courtroom at all. So do you think that will change the dynamic? I know each of these Trump trials is going to be the trial of the century, followed by the trial of the century, followed by the trial of the century. How do cameras in the courtroom change the dynamic?
From my perspective, I've always advocated for cameras in the courtroom. I think if there are proper safeguards, you can do it. Now, that's the key. So if you have witnesses, for example, for the prosecution, who might have their safety in jeopardy because they've testified, you really have to be careful about, obscuring their faces and doing things like that. But it occurs to me that if that case, and I don't think it's going to be tried, as I said before, the election in 2024, if it were tried before the election, it probably oddly provides a platform for the former president. It would be sort of performative, but I think he'd like to get on the stand and claim that he's being martyred and that he's being persecuted, not prosecuted, and he would probably welcome the ability to do that because, among his supporters it could resonate in terms of the election. I just don't think that he's going to get that chance. So probably by the time the case gets tried, I would think the election will be over, and so I don't know that it's going to have any special significance.
Let's talk for a minute about some of your concerns that you have brought up before, that you've written about extensively, and these are concerns about security. And you've talked about this in opinion pieces, I know, for the Philadelphia Inquirer and some other media outlets. Are you worried about the situation becoming potentially dangerous for the judges involved, the potential jurors, the prosecutors? How concerned are you?
Well, I look at it from the perspective of a former federal judge, and of course, when I was on the bench, we had protection from the United States Marshal Service. However, without letting out, state secrets, the fact of the matter is that unless a judge is under an active threat, you don't have 24/7 protection from the Marshal Service, and that's worrisome. Now, the Supreme Court has tightened up their protection. They pretty much have 24/7. It's a question of resources. I'm not blaming anybody, but there just aren't enough marshals to do it. I have long said that intemperate statements by our public officials, for the well-adjusted recipient of those messages, they can get mad, they can get angry, they can talk about it, that's fine. That's a First Amendment, it's a free country. But for unstable recipients of those messages, it's like a dog whistle, and it can lead to and foment violence. And what people should know is that Judge Chutkan, who's presiding, of course, in the Washington, D.C. Federal case, now has marshal protection around the clock. And I think that's a sad statement. I talked to someone who saw her in the cafeteria of the federal building in D.C., and, she's going through the cafeteria line with two marshals on either side of her. That's really unsettling to me. And frankly, it's a product of the former president and his supporters making inflammatory, threatening statements. Jack Smith, the prosecutor, has a 24/7 detail around him. And I think we're in a world of trouble when our public officials, in the service of their duties, have to have that kind of protection and be literally afraid for their lives and for their safety. And I might say one other thing about this. I understood when I became a federal judge that it was potentially risky, and it's not that I'm a fatalist. I'm not at all. Nobody wants to get hurt. But the fact of the matter is, where it's really difficult is with your family. And I had threats on a couple of occasions that I had U.S. Marshal protection around the clock. And I sort of accepted that went with the job. I never accepted that having my wife and my kids at risk was part of the job. And people need to think about that, and before they vilify, the folks who are doing their jobs. Judge Chutkan didn't pick this case; it was assigned to her. Jack Smith, I would say, is a professional prosecutor. He's doing what he believes is correct, and according to the charge that he was given by the Department of Justice, to so vilify them that people want to hurt or kill them, I think is outrageous.
Let's talk about another issue, which is the idea circulating in legal circles, and it's been written about in several news outlets, the idea of the 14th Amendment and the fact that it disqualifies former President Trump. Now, this was a post-Civil War statute. The idea that folks who have participated in an insurrection cannot hold public office. Do you think this holds any water?
Well, it's a creative legal argument, but I'm going to be practical here and give you sort of a prognostication from the standpoint of a former federal judge. And I just don't think, at the end of the day, the Supreme Court of the United States is going to accept that argument as a way to knock the former president off the ballot. It is something that is an intellectual point. It's a legal point that scholars love to work on, and you can make an argument that the amendment fits this situation. But the fact of the matter is that I do not think a majority of this Supreme Court will rule in a way that takes the former president off the ballot. It's just too much of a reach in this situation, and I think they'll let the election be decided at the ballot box. It's a political question in a sense that they typically wouldn't wade into.
What are we not asking that maybe we should be about these prosecutions? Is there a lack of information or maybe a narrative that you're not seeing that, as a former federal judge, you would like to see out there?
What I would say to those watching and listening is that let this thing unfold. And if you have the opportunity to, for example, dig into the facts of the Mar-a-Lago case, you can call up the indictment, you can take a look at it, be, sort of considered consumers of the news. you can make your own decision. But there are some pretty grave allegations in this case that go to the essential honesty, I think, and fitness of the former president. They haven't been proven yet. They're simply allegations, but I would urge people to stay tuned because federal charges in particular are the gravest things. Whatever Donald Trump projects, it is most unsettling, to be the target of a federal prosecution, and his liberty is really in jeopardy in these cases. So this is not, a political show. This is real life. Seldom did I ever see a defendant. In fact, I never saw a defendant in my almost 20 years on the bench who was indicted in so many different jurisdictions at the same time. And again, I would counsel those who are dedicated and interested in the election, and I hope that would be most, if not all, people, to be circumspect about this and take a look at beyond the sort of bluster and the political maneuvering. Take a look at what's really there and let the process take its course.
President Jones, thanks so much, as always, for being with us.
Always a pleasure. Great to see you, Craig.
Great to see you, too. President John Jones leads Dickinson College, home of the Dickinson Expert Show. I'm Craig Lane. Thanks so much for joining us.